Thank you very much, Mr. Chair and members. I present to you AB 178, which implements recommendations resulting from the March Sunset Review of the Board of Vocational Nursing and Psychiatric Technicians, as well as the Dental Board. 178 makes a number of changes, including removing the requirement that the executive officer of BVNPT be a licensed vocational nurse, registered nurse, or psychiatric technician. Secondly, requiring the Director of the Department of Consumer Affairs, DCA, to appoint an enforcement program monitor to the BVNPT no later than October 1st, 2015. Third, requiring the department's internal audit unit to review the BVNPT's staffing resource needs and requirements, and also fourth, imposing a temporary moratorium on the registered dental assistant RDA practical examination. During the Sunset Review, we learned the pass rates for the dental assistant practical examination fell dramatically over the last year. My real concern was the fact that we have people trying to enter the workforce and they were unable to because of some of the issues with this practical exam. The pass rates had averaged between an 80 and 90% pass rate over the last 4 years, and that fell to a 38% pass rate, a 19% pass rate, and then a 33% pass rate in different examinations. The sharp decline occurred after the examination had been recalibrated, and in my humble opinion, there was something wrong with the recalibration, or at least something needs to be addressed by the board. And we feel this one-year moratorium will give the board time to find out what just went wrong. I didn't want to see the students pay the price for finding out that answer and not being able to enter the profession. And that's why I had asked for that moratorium and felt that that would relieve the undue hardship on the examinees, as it really wasn't something that they could have any control over themselves. We know that there are some concerns about a temporary moratorium. However, we can be assured the public will continue to be protected. RDAs will continue to meet all the other licensing requirements, including passing 2 written examinations and completing their formal education or the 15 months of supervised on-the-job training, or a combination of both, in order to be licensed. Today I have with me Karen Fisher, the Executive Officer of the Dental Board, and Fran Burton, President of the Dental Board, to help answer any questions.
Very good. I don't see questions at this point, but are there witnesses in support?
Mr. Chairman,
Valencia.
John Valencia here, representing the Foundation for Allied Dental Education, the California Association of Dental Assisting Teachers, and the California Dental Assisting Association. Obviously, we're here on the portion of the measure relating to the RDAs. Assemblymember Bonilla and yourself presided over the Sunset Review hearing. There's something awry in the examination. The gyrations are testament to it, and the fact that these are entry-level positions, and this is a woman-dominated profession where the expense is significant, along with several other issues like accessing an exam. These are multiple issues that warrant a 1-year moratorium for a full top-to-bottom, bottom-to-top review. We're strongly supportive of this provision.
Thank you, Mr. Valencia. Others in support of this bill? Seeing no one, is there anyone in opposition? Good afternoon. You could sit down if you'd like.
Hi, my name is Kara Miyazaki, and I'm the Program Director of the Foothill College Dental Assisting Program. I'm representing educators from numerous Northern California community colleges, which include Santa Rosa Junior College, College of Marin, San Mateo City College, San Francisco City College, Sacramento City College, College of Alameda, and Diablo Valley College. I'm also representing schools like Mount Diablo, Loma Vista Adult Ed, Orange Coast County College in Southern California, and Butte County ROP. And many of these educators are members of KDAD. We are opposed to the moratorium for the RDA practical hands-on exam, and the reason is that dental assistants are allowed to work inside a patient's mouth with sharp instruments. Without a manual dexterity test, it's a danger to the public. An analogy would be like allowing teenagers to take a written exam for their driver's license without actually taking a driving test. I did bring with me some images of the instruments that dental assistants are commonly used in their dental offices. May I share those with you?
Sure, but I think most of us have had our teeth cleaned or worked on, and we know those sharp instruments, but if you'd like to show them, that'd be fine. And nor do we like them. The sergeant, take them, thank you.
So I understand one of the arguments is that dental students and dental hygiene students, that they are moving to licensure by portfolio. And one of the reasons why they're moving to licensure by portfolio, and California is actually the test state for that, is that dental hygiene graduates and dental students work on live patients. And that's a major concern for many of the states working on the live patients. For the RDA practical exam, the dental assistant graduates, they're working on artificial tooth models. And that way they can test a skill without any harm to a patient. And so that's one of the reasons why we think that dental assistants need to be tested before they go and work on the public. They actually already do work on the public, but they're under the supervision of their dentist. But we think that's really important for them to have a safety skill sort of test before they actually get their licensure. For the occupational analysis, we do support the occupational analysis to provide us with information to improve the licensing process.
Very good, thank you. I have a question, if I could. So, and you did imply or mention that there is some actual work on a patient by a dental assistant at some point in time, and that would be, I guess, in a clinical setting during the educational time that they're present. How much time is that spent? Do you have an idea?
Well, dental assistants that go to a Commission on Dental Accreditation School are required to do 300 hours of unpaid internship in their dental office. They also work on each other sometimes, depending on what the process is. And if it's not something that's permanent, like removing part of the tooth, so they'll work on each other, take x-rays on each other, polish each other's teeth before they actually get to work on real patients in an educational setting.
So do you feel that in that situation, that if there were a problem with a particular dental assistant, it would be identified in those 300 hours?
Yes, they're closely supervised, and we're required, for the CODA-approved schools, we're required to visit the colleges, and we do get a site visit every 7 years by CODA. So they're closely monitored. The on-the-job trained, they are monitored by their supervising dentist, and they work for 15 months, and then they're certified, I guess, by the dentist on the application to take their RDA examination. And actually, those are the ones that, through a educational process, I can understand that that I would feel comfortable not having them take the practical exam. But for the on-the-job train, that's the dentist that's supervising them, is that going to be enough for the student to learn all the skills that they need to do, like they would in an educational setting? If they went to, I testified at the Sunset hearing saying that even under the Department of Consumer Affairs, hairdressers and people that do nails and barbers, they have to take a hands-on exam too, and they do it on wigs. Sometimes they do it on wigs, and that's a required process for them. So someone who's working inside someone's mouth, inside the public's mouth, that would be an important concern to maintain a practical exam. I do understand that the practical exam does have its problems. I understand that, and I'm at the exam too many times. So the exam has been, last year it did dip down to a very low rate. This last year, and this is anecdotal, it seems like the exam process is actually better, and more candidates are passing the exam. For instance, for my students, they were doing okay. So it's kind of like a catch-22. I understand there's problems, but I also feel that for the public safety, that working with sharp instruments inside someone's mouth, they should be tested before they actually are given their license. And when they get their license, they can do more procedures inside a patient's mouth.
Very good. Thank you very much. Others in opposition, you'll excuse me, I have to vote.
Should I sit down as well?
You certainly will.
Thank you. Hello, my name is Eloise Reed. I've been an RDA since 1977, And I'd like to take you back to 1977. I was one of those poor kids who got to go to the Bryman School on a grant, and I was trained by a very nice teacher. But I only had to take a written exam to become an RDA. And the skills I had to learn in the office with those very sharp instruments that you're all very familiar with now, I can only imagine the damage that I did on a patient as I learned to do those procedures in an office. I can tell you for public safety, I see firsthand dental assisting students who graduate from these programs. And keep in mind, schools, public and private alike, their only concern is their enrollment and their graduation rates. That's really all they're concerned with. They're not concerned with public safety. As an instructor, I go into offices and I watch these students perform their internship, and some of them they graduate, they're ready to be a dental assistant. They're not ready to be an RDA. So when we graduate them with the best skills we can possibly give them. But some of them are not ready to be an RDA. And to simply take 2 written exams to become an RDA isn't in the best interest of the public. So I do feel that an unbiased third party monitoring the capability of a dental assistant and giving them a license instead of school, I think that is truly in the best interest of the public. So I'm opposed to the moratorium. I am very much opposed to it. I'm in favor of the occupational analysis because there were many things wrong with the exam. We did see improvement after the Sunset review. The Sunset Board asked the dental board to go back to the way they used to grade. We did see improvement, but as a consumer and as an educator and as an RDA from 1977, having taken the written exam only, I am opposed to the moratorium. Thank you.
Thank you. Any additional witnesses in opposition? Back to the committee then, I think I'm the only one. Do I have a question? Now, Ms. Bonilla, would you like to close?
Well, thank you very much. I think that I would like to emphasize that it's just a one-year moratorium. It's not a moratorium for all of time. I think that many of the RDAs have their training actually in dental offices. That's one of the pathways. And I think also in the programs, there is the opportunity for the actual hands-on work as well. I do think it is very important to have that practical examination. We just want to make sure it's the right examination, that it's not becoming something that's actually prohibitive to our students actually entering the workforce. So with that, I do ask for your aye vote.
I do have a question. The individuals who are seeking the registration now might be in the pipeline. Are they affected by the moratorium in terms of getting, their final certificate of completion and being able to move forward, getting their, is this going to affect them at all?
Well, hopefully it'd be a positive effect.
Karen Fisher, Executive Officer of the Dental Board. Taking away the practical examination at this point, as long as the candidates have all their other requirements, they will then go to licensure. So the delay in having the practical examination will have no effect in delaying their licensure.
So they would be able to practice, even those who are in, let's say, the written part now, they wouldn't be required now for this year to have the practical. Will that affect their licensure? No. Oh, okay. Then we don't, I don't think we bother calling the roll at this time. We'll wait till folks are back, and then you can call the roll, and we'll let you know if we put it on call until all the members are here.
Thank you very much.
But the recommendation is support. So-
Thank you.
Okay, you're welcome. What is our next one? Catching up here, would it be 3? AB is the next one, 483. That's Assemblymember Patterson and AB 483.
Thank you very much, Senator, for the opportunity to present.
I feel like I rule the world at the moment.
Enjoy it. Thank you for the opportunity to present AB 483. This is a bill to decrease the financial burden on newly licensed professionals. This bill is a reintroduction of AB 1758, which passed unanimously out of this committee last year and with strong bipartisan support off the Assembly floor last year. Currently, initial licenses for certain professions, including veterinarians, acupuncturists, dental hygienists, and others, expire on the last day of a licensee's birth month on the second year of their second term. This policy, however, has the unfortunate consequences that when a new licensee must pay a full initial license fee, then they have to pay for a license renewal just a few months later when their birthday falls. For example, a constituent of mine, unfortunately could not be here with us today, but did testify in front of this committee last year, recently graduated from school and received her dental hygienist license. Right after receiving her license, she was notified that it expired in 3 weeks due to her birthday and that she had to pay an additional $160 renewal fee. This occurred only a few months after she paid $575 for her state exam and application and $100 for her initial license. AB 483 would standardize initial licensing fees for these professions by requiring them to be prorated on a monthly basis based on how many months elapse between initial licensure and the first license renewal. This prorated monthly system is similar to one already in place working effectively at the State Dental Board. This makes a common sense change to a policy that can adversely put barriers in front of professionals who are just starting out in their careers. I have with me here Christina DiCaro, who represents the California Veterinary Medical Association in support.
Thank you, Madam Chair. Christina DiCaro, representing the California Veterinary Medical Association. We are in support of the measure. 2 weeks ago, we had the dean from the UC Davis Veterinary School speak to our association, and he said the average debt load for the students coming out of UC Davis Vet School is $135,000. So anything that we can do as we help them get their initial license, make it a little bit more manageable, decrease some of that debt load would be appreciated. Thank you.
Any additional witnesses in support? Those in opposition? Assemblymember, would you like to close?
Thank you. Do appreciate the opportunity to present. It does give us, I think, a chance to be an encouragement to these professionals as they move forward in their chosen life's work, for the state to be an encourager rather than a discourager, and I think that's what this bill can do.
Great. Well, Assemblymember, you'll notice that there's few of us up here to vote, so we'll put that on call. It does have a recommendation for support.
Thank you. Thank you very much.
Next item is AB 525, Assemblymember Holden. I don't see, oh, here he is, yes. Welcome.
Thank you.
Proceed.
Okay, thank you. It's a pleasure to be here with you today and your colleagues, who I hope will be back soon.
I think they might be here in spirit. I don't know.
I'm sure, I'm sure. I'm presenting Assembly Bill 525 to prevent hardworking small business franchisees from losing their business to ticky-tack violations that should not lead to termination, but do. Recently, a 7-Eleven whistleblower has testified under oath in federal court about his involvement in targeting South Asian 7-Eleven franchisees for the purposes of intentionally building a case for 7-Eleven to terminate these business owners, small business owners. By doing this, 7-Eleven keeps the fees paid by the initial franchisee while gaining additional upfront and ongoing fees from new unsuspecting franchisees, a process known as churning. The impetus of reintroducing this legislation is not to limit to 7-Eleven. Recent complaints filed with the Federal Trade Commission show incomplete or misleading financial representations made to prospective franchisees, arbitrary termination, and non-renewal of franchisees. According to a recent survey, 40% of surveyed franchisees have said they were threatened with termination or non-renewal for making a decision they thought was appropriate for their business. 78% said they have been required to make changes to their business that increased operating costs that were not offset by increased revenues. For these small business owners, this bill was carefully crafted to do three things: protect small business owners from being terminated arbitrarily, ensure that small business owners have an opportunity to sell or transfer their franchise without arbitrary discrimination, and three, provide small business owners an opportunity to monetize any equity they have built up in their businesses. Last year, when Senator Jackson carried SB 610, the governor stated a few reasons for his veto. One, the standard for termination, substantial and material breach, was ambiguous and unprecedented. AB 525 changes the standard for termination from good cause to substantial compliance. Good cause is a legal standard rarely, if ever, used in contract law, and the ambiguity of this statute has been a litigation nightmare. Substantial compliance is a standard used in at least 5 other states: Minnesota, New Jersey, Rhode Island, Wisconsin, Nebraska, and Arkansas. When we examined these states, we wanted to be sure that this substantial compliance standard would not increase litigation or stunt job growth. With 81 franchisors, including leading brands such as Dairy Queen and Buffalo Wild Wings, Minnesota is a prime example of a strong franchise growth in a state with strong franchisee protections. Rhode Island is another example, is the home of Dunkin' Donuts. 2, the governor also stated that the supporters and opposition had diametrically opposing views, and he wanted more of a collaborative product. The opposition has consistently outlined 5 issues with this legislation, and I have made a good faith attempt to address as many of their issues as possible. Renewals. I completely eliminated the section of my bill that dealt with strengthening opportunities for small business owners to renew their franchise at the request of the opposition. Monetization. I completely eliminated the section of my bill that allowed franchisees to monetize the equity they had built into their business over the term of their contract. This provision recognized that there is value in being able to come into owning a business and not starting from square one. Existing law makes it easy for franchisees to liquidate their inventory. My bill expands this to include equipment, supplies, furnishings, and fixtures. I clarified at the request of the opposition that arbitration is allowed if a franchise agreement mandates it. I clarified that a judge or arbitrator would not be required to reinstate a franchise that is impossible to reinstate. Under the leadership of the chair, last Monday I agreed to an additional set of technical amendments raised by the opposition to clarify the definition of reasonable as it relates to transferring a franchise. I'm also accepting the chair's proposed amendments to include prospective date language, even though committee staff previously stated that it was not necessary. I'm accepting the chair's proposed amendments to place a hard cap of 75 days on the period to cure a violation. Lastly, I'm accepting an amendment to clean up language I accepted from the opposition regarding transfer to controlling interests. From the beginning, I've worked to address the opposition's concerns from last year, and I've taken amendments to address their concerns this year. The governor has asked for a bill that reflects more collaboration. I have taken 5 sets of amendments that, at the request of the opposition, to make this a much more collaborative product in comparison with last year's measure, which I wholeheartedly endorsed. The decision to amend the bill was not made by me alone. It was made in consultation with franchisees who take quick breaks from making sandwiches and Slurpees to advise on a bill they believe will benefit future franchisees. These small business owners represent the backbone of our economy. They are not demanding everything, but they deserve laws that give them basic protections, just like non-franchise contracts are required. For these reasons, I respectfully ask for your aye vote.
Thank you, Mr. Assembly Member. I appreciate it, Mr. Holden. Witnesses in support.
Yes, Chairman Hill, Vice Chairwoman Bates, and members of the committee, thank you for your time. My name is Keith Miller, and I'm a Subway franchise owner with locations in Auburn and Grass Valley, the sandwich maker he refers to. Slurpees are past my pay grade, I think. I'm also chairman of the Coalition of Franchisee Associations, which is the largest franchisee organization in the country. We only represent franchisees, and our directors are put on the CFA board by their fellow franchisees. While the franchise industry is large, the franchisee leaders communicate closely. We find that our contracts and issues in franchising, no matter what line of business we are in, are fairly common. The primary issues and bad players in the industry are well known among us. We have to remember that it's the franchisees that invest and pay taxes in California, not the franchisors primarily. It is the franchisees that support their communities, and it is the franchisees that create the jobs in California. What AB 525 is really about is protecting franchise owners in the state first, making sure the franchise company does not act as prosecutor, judge, jury, and executioner. You know, we often hear that it'll make it harder to terminate franchisees. Look, as a franchisee, the last person in the world that wants a bad franchisee in my brand is myself. However, they still deserve a due process. They've invested in this business, and it shouldn't be easy to terminate them. There should be a process. And that's why franchise owners in this state deserve basic protection rights. They do own their business. And protecting those who are actually doing the investment will not stop investment, but actually give incentive to invest more. Well, technical terminations that we talk about are rare. We'll hear that they really don't happen that often. What you more often see are forced sales, transfers, or settlements as a result of being out of compliance or marked out of compliance that result in the franchisees losing much of their investment. Recently, actually last week, I was doing a little research on some federal information, and I came across the House of Representatives floor speech by then Congressman Howard Coble in 1999 when he introduced franchise legislation. He just retired this last year. And he stated, and I quote, "As a conservative Republican who supports smaller government and less regulation, many people have asked why I support franchise legislation. First of all, this legislation is not about bigger government and more regulation. It is about protecting freedom. The freedom for small business entrepreneurs to contract fairly, honestly, and without fear of retribution," end quote. I think that was fairly well said by him. As a group, we have been over backwards to reach compromise with the opposition, taking, as Mr. Holden stated, many rounds of amendments. We have patterned our efforts after current laws in other states. We have taken out the mandatory renewals from the original bill, and as he stated, we have stepped back from most of the monetization of equity, even though our original language came straight from the opposition's statement of guiding principles. I guess putting the principle on paper is a lot easier than actually meaning you want it acted upon. Yet we remain committed and have taken the amendments from the committee to working with the opposition on reaching some level of agreement. But that also takes a point in time that they need to reduce their public rhetoric and remove their opposition. I'm sorry Ms. Senator Jackson isn't here. I had a little kudos to her for her efforts in bringing to light many of the issues in franchising, that we'll never forget her efforts and contributions as we continue this quest. I respectfully ask the committee for an aye vote. Invest in California by protecting those that invest in and create jobs in California. Thank you.
Thank you for your testimony. Good afternoon. Welcome.
Thank you. Good afternoon. My name is Ed Navalis. I wanted to share my experience with you all today regarding my years as the owner of a franchised small business. I have an MBA and extensive business experience, especially in the field of healthcare. In 2008, I left a career in corporate America to start my own small business, hoping to avoid some of the pitfalls of starting from scratch and to find the support and infrastructure that's available in a good franchise relationship. I chose to build a business with a relatively new franchise system called BrightStar Healthcare, which provides home health care to seniors, children, and others. I was number 45 of a system that now encompasses over 300 units across the U.S. It was growing, and I was promised both support and flexibility. I quickly discovered that I would receive neither. Instead, what I found was inadequate support, unrealistic and predatory minimum sales targets, and costly vendor requirements. By 2010, I had begun organizing fellow franchisees into an association. And at that point, the relationship soured. I was repeatedly targeted with both internal and external audits. I was repeatedly charged with violating the agreement for things so minor as cutting my own payroll checks rather than using the designated vendor to save money. And ultimately, my franchise agreements were terminated. It's hard to believe for someone who was once a recipient of numerous franchisor awards for sales performance. I was a top 10 performer who owned 4 territories. In the process of having my business taken away from me, I lost my investment. My home, my family. And I was pretty stressed with a lot of personal consequences. I remember during these stressful times sitting around the dinner table and all the tension in the air, excuse me, and we were filled with anxiety, dread, and stress. It took its toll. I'm a father of 3 undergoing a divorce now. I carry an SBA loan from my time as a franchisee, and I'm fortunate that my current circumstances as an independent small business owner allow me to continue servicing that loan. But many who were in my cohort of BrightStar franchisees are not so fortunate. They lost hundreds of thousands of dollars, some millions, and they've defaulted on their loans, of course. I believe it's no accident. In the case of many franchisors, this seems to be a business model. You recruit franchisees who take out $150,000 to $200,000 loans, set unrealistic minimum sales targets, terminate them if they don't meet those targets, then flip their territory and harvest another round of loans and ad infinitum. In that model, the small business owners are crushed. Taxpayers are on the hook, and the corporate franchisor reports a nice profit on their books. It really needs to stop, okay? Franchisees in California need basic protections around termination, like our counterparts in at least 16 other states. We need the ability to recoup a small percentage of the thousands of dollars we've invested in our businesses throughout the years. This is why I support AB 525, and I ask that you do as well.
Thank you, Mr. Navalis, and we really appreciate you being here today and sharing those comments with us. Thank you. Others in support? If you would be kind enough to state your name and be as brief as possible. If you have something new to add, that would be great. But if we're going to talk about the same subject, it might be, the same comments that were made. So new information would be wonderful. So thank you.
Scott Hauke.
If it's red, it's good. There you go.
There we go.
Thanks.
Scott Hauke, I'm the president of Small Business California. I really don't have a whole lot to add. This is a situation that balances an inequity, and we ask for your support.
Very good. Thank you. Appreciate that. Yes, sir. Welcome.
Harvinder Sidhu, and a franchisee of 7-Eleven for 28 years, and I ask for your strong support.